Hello, everyone. I'm so pleased to see so many members of our community join the Holy Cross LGBTQ Alumni Network for this important and timely conversation about the Supreme Court's ruling that includes LGBTQ folks in the protections of the Civil Rights Act. My name is Phil Dardino, and I'm the Alumni Network Chair, and I'm also a member of the class of 2002. Throughout our conversation tonight, I encourage you to submit questions to our panelists using the Zoom Q&A function at the bottom of your screen. We will be recording this session to make it available to all of our members through social media and the Holy Cross website. I'm happy to welcome our moderator for the evening, Thomas Landy, Holy Cross Professor of Sociology and Anthropology and Director of the McFarland Center for Religion, Ethics, and Culture. Professor Landy is the founder of Catholics and Cultures, a web-based initiative to explore the religious lives and practices of lay Catholics in their particular cultural contexts around the world. He's received the Association of Catholic Colleges and Universities President's Distinguished Service Award for his dedication and exceptional commitment to Catholic higher education. Tom Landy is a longtime supporter and mentor for LGBTQ+ students at Holy Cross, and we're very grateful for his many years of service to our community. I could go through all of his accomplishments for our whole hour together, but without further ado, I'd turn it over to Tom Landy.
Thanks very much, Phil. When I know your class of '02, it makes me realize that you are graduating pretty much not long after I was starting there, so that's a while. I'm really grateful to Phil and the Holy Cross LGBTQ Alumni Network. I trust that there are some former students here on Zoom who are now in the LGBTQ network. Zoom doesn't let us see you, and many others who I'm happy to meet. I also really want to thank Tom Cadigan in particular. In the years that I've known Tom, he's never been less than 100% supportive, gracious colleague, and a real support when it came to starting this alumni network. He played a very important role in that I'm grateful for and probably goes unheralded, but he was really enthusiastic about that. It's my pleasure to introduce three panelists we're going to talk to today. The first is Jamie Hogue of the class of '98. Jamie's an attorney who serves as the college's Director of Government and Community Relations and Assistant Legal Counsel. Before that, he served as a legislative aide to Congressman James McGovern, now Chairman of the House Rules Committee, as an assistant to the late great Mayor, Boston Mayor Tom Menino. More recently, he worked for Governor Deval Patrick as the Director of Federal State Relations and as a Deputy Chief Legal Counsel. Prior to joining the Patrick administration, Jamie was a litigation associate at DLA Piper. He serves on numerous nonprofit boards, is co-founder of the Voter Protection Corps, and lives in Watertown, Massachusetts with his husband, Eric Schuppen. Francine Rosado-Cruz of the class of '94 is Chief Diversity and Inclusion Officer at Davis, Polk, and Wardwell, LLP. She's also a trustee of the college and chair of the trustees' new Diversity, Equity, and Inclusion Committee. Among her past accomplishments, she served as Global Director for Learning and Development for Diversity and Inclusion on Microsoft's Human Resources team. And recently, she joined the New York City Bar Association's Diversity, Equity, and Inclusion Committee. Michael Xavier is of the class of '96. He's a partner and family law attorney at Prince Lobel LLP. He has 18 years of experience working with families in distress caused by divorce, custody, child removal, modification, guardianship, will contests, and related issues. His practice includes legal issues pertaining to same-sex marriage, adoptions, and assisted reproductive technology. He works closely with clients in same-sex marriages in areas such as child custody, especially in states where their marriage isn't recognized, and tax implications for same-sex couples who are legally married, and he helps to clarify the rights and interests of sperm donors, egg donors, and their surrogates. So thanks to the three of you for being here, and thanks to our audience, both students and alums and faculty, for joining us. I guess I'd open by saying that although I have a very personal stake in the issues on the table, good reason to be well-informed, perhaps naively, I settled into thinking that when Neil Gorsuch penned a Supreme Court ruling with a 6-3 majority in 2019, declaring that gay and transgendered workers are protected by the Civil Rights Act, that things were settled, everything else around here would just be a matter of tinkering at the edges. That ruling, Bostock versus Clayton County, Georgia, declared that gay and transgender workers are protected by Title VII of the Civil Rights Act of 1964, which prohibits discrimination based on race, religion, national origin, and sex. And indeed, it's that ruling that helps bring us here today in terms of where we go from here. Maybe the question I'd like to start with is this. Aside from the question of whether a new, more conservative Supreme Court could reverse itself someday, which is an important question, I think I want to ask something more specific that I hadn't given too much thought to. Did the court rule on civil rights protections for LGBTQ people as a constitutional right, or only that this is how we have to interpret one law that the Congress made? So if Congress changes the law, would those worker and housing discriminations that seem sort of sealed in the Constitution, would they disappear? Give that over to anybody who can help us understand that in the law.
So I'm not an attorney, I'll just give that disclaimer, but the research that I did do on the topic did say that the opinion really was related to the workplace, and that the work ahead of us and that we really should focus on is on the state level, because while a lot of these cases do come at the state level, and then other opinions that I've read on the ruling have said it really doesn't help protect people, you know, when they're going about their daily lives, right? If they're going to a business, it doesn't protect them from being discriminated against from that perspective. I know that that's exactly what you were asking, Tom, but that's the first thing that came to mind for me in thinking about this opinion that came out.
Okay.
And I would say that the case itself was about an interpretation of a statute. So I think that was a narrow focus of the case. It wasn't this sweeping constitutional question or constitutional answer, if you will, that affords protections to members of our transgender community and members broadly of the LGBTQ community. It was a very narrow question that the court answered, the court addressed. And so while I think it was definitely cause to celebrate the decision, because it was important and it does have enormous impact, it doesn't set up a foundation that it doesn't set up a sturdy foundation for the future, if you will. And it does leave open a lot of questions that we'll probably talk about here. One involves the balance between LGBTQ rights and religious freedom, just for one of many examples. And so I think the case was important and it was a victory, but I don't mean to be the Debbie Downer or the skunk at the garden party, so to speak, but I think it does leave there were a lot of holes that I'm worried at how they're filled.
Yeah, I agree with Jamie. I think he's absolutely right. I think it's easier for the justices to work on and affirm a case where there's an interpretation issue of a statute that's been enacted by legislation rather than themselves legislating to the United States. So I think that it was a narrow issue. I think it was an important decision, but it is very different for the court to interpret a statute than for them to provide, you know, substance due process or equal protections that the legislature or the American people haven't themselves put into place. So I agree with Jamie, and I think that's I think that's the concern that I think is being raised by the LGBT community now, is what protections may be chipped away going forward, because we are now looking at a court with a different makeup potentially in the future. And, you know, the court is not going to, I think if we have a new court, and I don't think the new court is going to necessarily expand our constitutional rights. They're going to defer to the legislature and the American people. And that, I think, is going to be one of the problems that we may face with a new construction of the courts.
So I guess I'd say not only do we have to worry about, we have the ghost of Ruth Bader Ginsburg staring over us, over Jamie's shoulder, and that's a legitimate concern. What can happen with the court? And I probably, before I started thinking about this, that was my primary concern. But am I wrong thinking that if one party moved in, could turn this all around on the 1964 Civil Rights Act, that actually an act of Congress can probably overturn what we think of as a right or a settled situation?
Well, an act of Congress could certainly clarify the rights that are afforded to members of the LGBTQ community. I mean, these questions of statutory interpretation are questions that the court considers because they are vague and the language is vague. And so a legislature, the U.S. Congress, if we have a new makeup of Congress, could clarify and solve all these problems by making sure these questions aren't uncertain and there isn't room for interpretation. And I think that's what legislatures have to do. That's what I hope the U.S. Congress does. I mean, this obviously raises, this conversation I think was scheduled before we lost Ruth Bader Ginsburg, but the makeup of the court is always an issue for in any election season. I think particularly in this election season is especially relevant. But the courts matter, but the legislatures matter too in terms of these questions of statutory interpretation. So hopefully, I am not speaking on behalf of the college when I say this, just as a disclaimer, that we have a change in leadership in Washington, D.C. and a supportive Congress that maybe will pass legislation that affirms these rights, that we don't have to worry about who's going to be on the court for the next 40 years because these rights are clear and there's no doubt and no room for interpretation left.
So the interpretation would be there, and just as a new legislature could clarify them one way, a legislature could also clarify them away.
Oh, sure.
So there's a good deal more at one big level as a basic right. So there aren't at that level. So it's not a big ruling with big basic rights, I think is where you and Michael have clarified for us that we haven't yet gone. Yeah. So it's a matter of thinking about the legislature and a matter of thinking about the composition of the court.
Absolutely.
Great. On Monday, if anyone thought that our conversation was less than relevant, Clarence Thomas went out of his way to inject a new sense of urgency into tonight's conversation. He wrote a 4-page statement, it's called, as I looked at it, that Samuel Alito signed on to, prodding the court to overturn Obergefell versus Hodges. I'll admit that Thomas's action made me incandescent with anger for a while, as some people know, but let me ask, how does this particular statement matter practically, except that he does have power as a Supreme Court justice? Earlier in the week, in another college election event, a couple of faculty suggested that it doesn't mean that much legally, the status of the statement. It's not a dissent, but is it legally just a meaningless tantrum? Is it a symbolic cry from a heartless cur? What's going on there?
So I don't think there's any legal viability to the statement. And I think this sort of segues into, I think, one of the questions we have from an anonymous attendee. Can the court sort of go back on what they've ruled on? The short answer is, and I did some research. I will give you a disclaimer. I am a family law lawyer. I'm not a constitutional law lawyer, but we know enough dealing with family law issues that with the intersection of constitutional law, I can speak to my understanding, which is that, there is this concept in the law called stare decisis, which essentially means that Supreme Court justices and justices are supposed to rely on precedent when making future decisions. They're not supposed to go back on what they've already decided, and that's called stare decisis. I will tell you, and in the past, throughout the history of the Supreme Court of the United States, there have been about 300 decisions where they have overturned themselves. So that has happened in the past throughout history, where they've overturned prior decisions. Luckily, they were in a good way, abolishing, slavery and second-class citizens with people of different races. So it was in a good way they've done that, but they did overturn themselves. So it is not entirely impossible that a new composition could potentially do something. It's more likely that there may be a chipping away of rights. Take the Obergefell decision, which legalized gay marriage. It may be that some states challenge certain provisions or certain rights that married people have with each other, benefits or pensions, or there may be certain things about marriage that certain states may challenge, that may go up to the Supreme Court, and they may say, well, just because we've legalized your marriage doesn't mean that you're afforded these particular rights. So there could be some chipping away. Roe v. Wade is another decision where people are sort of concerned that the Supreme Court could do away with, especially considering, the possible nomination of Amy Coney Barrett. There have been post-Roe v. Wade decisions, such as I think there's one case, Casey versus Planned Parenthood, a Pennsylvania case where there have been restrictions on abortion rights. There has been some chipping away. So that is a possibility in terms of the rights that the Supreme Court has afforded us in the past. But, is it likely that, Obergefell or other big decisions legalizing gay marriage are going to go away? Probably not. I think that people are concerned about it, especially when you have, somebody like an Amy Coney Barrett who is 47, I think, years old and could be on the bench for a long time. And then you've got Justice Kavanaugh, who's also really young. So when you've got justices on for so many years, the tenor of the court could really change. But, so that's why it's important to have, good legislatures and, who can enact these laws. But, so it is a concern. And and this may be a long-winded response to maybe a more discrete question. But, Obergefell, for instance, is a 5-4 decision, but, the justices that were in favor are now gone. Ruth Bader Ginsburg, Justice Kennedy wrote the decision, he retired. So, so do I think that there's a threat of chipping away and watering down rights? I do. I think that's a problem.
I would say that Justice Thomas's statement should be surprising news to no one. It is not exactly breaking news. I did not lose sleep over it because I wasn't surprised about it. It was more of the same from him, from Samuel Alito, and that group of justices. I don't mean any disrespect, but in terms of their opinion, their views on this issue, I have no respect for them on this subject, on their views on the subject. I think that Michael is exactly right. The concern is not overturning the case, though I would say that we've benefited from justices overturning cases before. Lawrence v. Texas overturned Bowers v. Hardwick. Bowers v. Hardwick upheld the criminalization of sodomy between consenting adults. Lawrence v. Texas overturned Bowers. So there are cases where it goes both ways, if you will. But I think that in this case, where I mentioned this at the beginning, my concern is when the court starts hearing cases about family law, Michael's area of expertise, and also about the balance between LGBTQ rights and free exercise of religion, the First Amendment right to practice your religion. That's my concern for the future of this court, in that the court's going to say you can discriminate against same-sex couple because of your First Amendment freedom of religion rights. Your freedom of religion rights, I hate to use this word, but Trump my and my husband's LGBTQ rights as same-sex as a same-sex married couple. So it's the balancing that I think presents the most risk for our community in the future, in future cases.
Great. I do want to come back to religious issues. I don't know, Francine, was there anything you wanted to add to that, or?
No, I think they both covered it. I mean, I was reading up on what Clarence Thomas said, and again, not surprising. And I think, his argument, and again, this is just my personal opinion on the religious freedom superseding the rights of LGBTQ plus people doesn't hold water. Certainly from a workplace perspective, we always lead with at least all the major corporations I've worked at, with inclusion, that's even better than what the law says. So that's what I'd add on that. Thomas.
Let me ask you, since you're talking about that, because one of Thomas's complaints in that was that the judiciary was leading the legislative branch in a way that was inappropriate. But in terms of where the workplaces are in America, are they being dragged along, the corporations you work with? Maybe I'm not talking about Chick-fil-A and Hobby Lobby, but are they being dragged along, or where are they leading things?
I will say, and again, the companies that I work with, like Microsoft, I also worked in the publishing industry. No matter what the local or even international legislation said, we always led with inclusive benefits, inclusive rights. You know, no matter, so for example, working for a global company like Microsoft, we always had to worry about people who were relocating to countries where, you know, LGBTQ employees would, you know, even their lives would be at stake. So wherever we operated, we always led with, you know, our people are our people and they have rights and we will protect them and they will have the same benefits. So I think that it would be hard from a workplace perspective to go backwards on, for example, the benefits that we're offering. And as a matter of fact, as we're moving into open enrollment season for benefits, you know, I just had a conversation with our head of benefits on how do we be even more inclusive, you know, with our family building benefits. You know, we're already pretty inclusive from a transgender perspective. So I will say the workplace trends, at least for your major corporations, are not matching, you know, this trend towards more conservative views on the rights of the LGBTQ plus employees.
And I'm sure you'd agree with me, we don't want to leave out the people who are working for smaller entities who don't have those kinds of benefits. But
right.
And so overall, the culture.
So that's where the state laws are important, because the federal law really covers 15 employees or more. So you're right, if it's smaller employers, you know, how do we ensure and guarantee the rights of those people? You know, you gave some pretty visible examples of different brands that have just, you know, put a stake in the ground on the other side of the issue. So I think we will still see outliers like that, but I think most places are going to land and keeping inclusive benefits, inclusive workplaces, you know, no tolerance, non-discrimination policy. I think it would be really hard for a workplace to see the talent that they have and you know, just turn away and not support their people.
So in that sense, I suppose it's driven by a fear of really losing talent, that young people don't want to work for the kinds of companies that are going to discriminate, and the winners and losers will sort themselves out accordingly. Let me shift gears a little bit and just go back to maybe stick with the court, but are there any particular pending cases that to the Supreme Court that we should be paying attention to right now in the docket? Do you know, or there may be hypotheticals, but is there any?
So
Yeah.
Jamie, you emailed the other day about that one case. It's a Pennsylvania case, or I forget, is it a Texas case where where foster parents, gay foster parents, are trying to adopt or want to be foster parents, and there's an issue as to whether or not they have the right to do it because of their same-sex status.
It's a case out of Pennsylvania, specifically Philadelphia, with Catholic Services. Philadelphia, the state of Pennsylvania, and in particular the city of Philadelphia, provide subsidies to foster agencies that encourage and support foster parents. Well, they have a policy of making sure that their subsidiary, the agencies that they subsidize, do not discriminate against LGBTQ individuals. Well, the Catholic Charities of Philadelphia announced that they would not deal with or facilitate adoptions for LGBTQ individuals. And because of that, the city of Philadelphia said, we cannot do business with you anymore. We cannot subsidize your agency because of your non-compliance with our non-discrimination policy. now the social service, the Catholic Charities organization, sued, and now the case is winding its way up to the Supreme Court on the issue of whether or not what's the balance. Their right as a Catholic agency to practice their religion as they define their religion, I should say. I think many people would agree, would argue, I would agree with the fact that discriminatory policies against LGBTQ individuals are not in line with Catholic social teaching, but that's my perspective. But they're arguing that their First Amendment rights to practice their religion supersede the government of the Philadelphia's ability to enforce its non-discrimination policy against LGBTQ individuals and deny them this state funding, if you will. And so the question is coming back to the court, is the same issue that the court addressed, but took a detour in the Masterpiece Cake case, where this was a case that was based in Colorado. Same-sex couples went to a private business, a baker, and asked for him to make a cake for them for their wedding. He denied their business. He said he would refuse to do business with the same-sex couple or make a cake for a same-sex wedding, and they sued. The case wound its way up to the Supreme Court. Now, in that case, the baker won, but the court decided the case on a very narrow point. The case was decided not on the larger constitutional principles of the balance between First Amendment for exercise of religion and the rights of the LGBTQ individuals against discrimination. But in that case, there was evidence in the record that the Civil Rights Commission in Colorado clearly discriminated against the baker because of his religion. There was statements on the record of them saying derogatory things about his Catholic religion, and the court said that we're not deciding the larger constitutional question. We're deciding this case on that very narrow ground that the Civil Rights Commission discriminated against him because of his religion. And so so that case is coming back to the court on this, and the concern is that they'll likely address the issue, the broader issue of the balance between religion and the non-discrimination policies. And so that case, the Masterpiece case, will, in a different form, call the question again through this Catholic Services case that's going to be heard this term. I think later on I think it won't be heard until January. Is my understanding, because the docket for this fall is already packed. So that goes back to the constitution of the court. That's why, in a case like that the makeup of the court matters. And so if we have a 6-3 conservative court, then I think that we know where the scales will tip in that type of case. At least I fear we know where the scales will tip in that type of case.
Yeah. So there's been, JB, I think you're absolutely right, and and I think it's going to be a 6-3. Well, I mean, I think we all, not all of us, but I think that most people can agree it's going to be a 6-3 slant in terms of ideology. There's the question of, Chief Justice Roberts, who I think wants to make his mark and has been sort of, in some decisions, aligning with the liberal justices. I'm not sure that he will in the future, but I think that with the possible inclusion of Amy Coney Barrett, and now with Kavanaugh, I'm wondering what that does for him and him making his mark on the Supreme Court, and whether or not he's going to become more moderate or not. But I just want to sort of throw that out there for a potential discussion.
I mean, he could become the next Ruth Bader Ginsburg, and it still wouldn't matter.
I'm not sure.
I'm just saying, hypothetically, he could become progressive. He can turn into the next David Souter. David Souter, appointed by George H.W. Bush or Kennedy. Exactly.
Kennedy was appointed by Reagan.
Reagan. Both turned out to be not the poster child of the conservative presidents that nominated and put them on the Supreme Court.
Right.
And so if it's a 6-3 court, if we lose, even if we gain one vote from Chief Justice Roberts, it's still 5-4 tipped in the balance of conservative. And so That's why elections matter. That's why who sits on the Supreme Court matters. Obviously, if we don't already know that.
Is this a question of money? I'm always struck in one of these things that the church wants to get money from the city of Philadelphia and has a right to do it. So if you took money out of the equation, is the argument that they couldn't run their own adoption agency or something? But the paradox of we have a right to get money from the government and have the government not tell us what to do.
Yeah.
Is one that
I think it's an excellent question, and sorry for me to jump in, but in this type of case, I don't think it's about money. I think it's about the principle. The ever since the Masterpiece case was decided the way it was decided, a lot of litigation groups and a lot of advocacy groups were searching for the next case, searching for the next opportunity. These cases don't make them to make their way to the Supreme Court by chance. They get litigated in lower courts. They wind their way up through the process, and they're shepherded by conservative litigation, conservative advocacy groups that look for these type of opportunities nationwide. So this case was ripe for it. So that's why I think it's making the Supreme Court, because the people were looking for the next Masterpiece case to bring it to the court again on better facts, if you will. They would argue that where the court could hear the case once again and decide the broader constitutional issue, and not give the justices a way out on the narrow question of such as what happened in the Masterpiece case. So I think maybe it's money, but I know these, and it happens on both sides. I mean, it's the progressives and conservatives, legal organizations look for these cases to make their way to the Supreme Court to establish what these long-lasting legal principles.
So Melanie McHugh points out in the Q&A, she says, but isn't the issue in the Kim Davis case that Thomas and Alito were commenting on, that the marriage license issued by the municipality shouldn't be influenced by individual religious doctrines, that the religious blessing part of a wedding should be separated from the license issued by the state, and the LGBTQ rights are protected from civil criminal law. So as I understand it, in fact, the court, by a large margin, turned the case down because that threshold wasn't met. So that's where what Thomas did was a sort of statement in the end. We're not going to hear this case because of that, but he still kept coming back and sort of nudging and saying the whole decision is problematic and ought to be backed down on. But as an agent of the state, her personal opinions, religious opinions don't matter in that sense. So just get out of the way or go. Is that correct?
Yeah, and I'll just roll for this quick point. I'll let others talk. But I think that what Thomas was doing in that case was sending a message to people who want to litigate this issue in the future, people who want to give the Supreme Court an opportunity to consider the question again. He was saying to the future litigants, don't give up. Don't let Obergefell get you down, so to speak. If you want to take this case, we'll be here for you. I'm around for a while. We have a 6-3 court coming your way. Keep fighting it to bring down Obergefell. It was definitely sending a message to people who are looking for these cases. He didn't care about the Kim Davis case. They all knew it was a losing case. But he was sending a message loud and clear to conservatives who want to litigate these cases in the future.
So, and I think to Jamie's point, I think that some of these litigants are looking for the right case. So if they thought that the Kim Davis case was the right case, maybe it would be a case that would have been taken up. Jamie, is that what your thought is? If they thought it was the right case, maybe that would have been the case that they could start chipping away at the Obergefell decision.
They'll keep trying until they get a case that the Supreme Court takes up, and they'll keep trying until there's a 6-3 majority. They have a 6-3 majority on the court where they think they have a winning audience.
To be fair, all ideological sides keep
exactly trying. Exactly right. It works both ways.
Correct.
So
we have a lot of interest around religious questions, and maybe stay with that. I mean, religious freedom questions are fairly dear to me. There is some guarantee within the Constitution about religious rights, but it is one of the places where there's tension. Certainly there are times when how do we deal with organizations, the Little Sisters of the Poor, or an evangelical church under the so-called ministerial exemption? So the idea is that the government shouldn't be interfering in how a religious institution runs its own goings on. If we get to pick who the priests are going to be, or we get to pick who our ministers are, and really the best thing is for government to stay out of that. We don't want a society where any government is interfering in selection of clergy or ministerial things. Now, some bishops have expanded that and tried to say that every mathematics teacher in the 4th grade in Indianapolis is a minister. So there's playing with that. But how do we begin to balance those two rights? Because there has to be some, the Constitution guarantees that. But how do you three think about those? I certainly think about them a lot and worry about them, but.
That is a tough one.
Well, I'm a firm believer in the free exercise clause and the establishment clause of the First Amendment of the U.S. Constitution. But I'm also a believer that those principles, those clauses and those rights that I hold dear to my heart should not be used as a cudgel to discriminate against other individuals. You know, you can practice your religion, and exercise your religion as you should, as one of the founding principles of our country and of our Constitution. But at the same time, you should not be given the platform and the authority to use your religion to deprive someone else of fundamental civil rights. And that's my view. Now, but where the court lands on these individual cases, maybe it's the nuance. Maybe there are a lot of nuances that I'm not catching. But as an overarching principle, that's where I stand.
Yeah, but Jamie, how do you? And I agree with you. You know, I think that some struggle that some people have is, you know, for instance, when you have the intersection of Catholic or religious organizations who sponsor things such as adoption or foster care, you know, and they have their own specific beliefs, but then, and there are other avenues for same-sex couples to have children in foster care and adoption from different agencies. So they don't necessarily have to go through a religious agency. You know, the question is, how do you deal with those competing interests? Because you have the religious agency, which has their own beliefs. You know, same-sex couples certainly have the right to adopt, have children, but they can, you know, do it elsewhere. They don't have to do it through a Catholic charity or religion.
But I would agree in the Philadelphia case, I would agree with the lower court that ruled in favor of the city. And because they said that the city was applying a non-discrimination policy equally applicable to everybody. It doesn't matter if you're what religion, if you're Pastafarianism, if you're the Church of the Flying Spaghetti Monster, which is a real thing, if you're whatever religion you are, their non-discrimination policies apply to everybody. So the issue in there is not a balancing of discrimination against religion. And if you're the Catholic Catholic services, as Tom pointed out, you don't want to do, but you want to deprive, you don't want to follow the broadly applicable non-discrimination policies of the city of Pennsylvania. That's great, but don't expect to get money from them.
You know, certainly when I look at all of these cases, I'm disheartened every time I see in Indianapolis or places, instances with teachers. I guess maybe to sharpen my question a little bit, should the law let any religious figures who want to discriminate like that set themselves on fire? I mean, it's a losing proposition in terms of young people. There's a reason why the numbers of evangelicals are down in the United States. There's a reason why so many Holy Cross young people I deal with can look at Catholicism and say, thank you, but no thank you. So I understand that. Is it the place of the law to solve this problem, or is it going to be the place of the rest of us to sanction and deal with that? Do you think, are we asking the courts to do something that we can't do ourselves?
I think it's a place that's exactly what the courts are for. Exactly what the courts are founded to uphold the rights of the individual liberties that are the foundation of our Constitution, of our government. So, I mean, if in terms of discrimination policies, I think that's where the courts do play a role. But I think it's broader than that too. Francine made the point too. Is it's a role of our elected officials broadly to make the case and to advocate. You know, I'm not worried about what happens in Massachusetts, and I'm a proud Catholic, by the way, and I'm not so disavowing my religion. And I have a lot of my very good friends who advocate for LGBTQ rights within the context of Catholic social teaching, and I'm proud to be one of them myself. But you know, I'm not worried about Massachusetts, because whatever the federal government does, Massachusetts can have additional protections. I'm worried about the teenager or the person coming out of the closet in Alabama who doesn't have the support systems and looks for the government for support and protection. And so I think the courts do play a role. We just can't let Rome burn, if you will, while we stand by as spectators. And I think that goes for the courts too.
No, I agree wholeheartedly with Jamie on this point. The courts do play and have to play a role. You know, look at Obergefell. Before that, you know, and, you know, I'm also happy and glad that I live in Massachusetts. You know, the Goodridge decision, which legalized Massachusetts, came out in 2004, I believe it was. And
with the Holy Cross alum as one of the key votes.
Sorry?
Well, with the Holy Cross alum as one of the key votes.
Oh, great. On the SJC?
Yes.
Oh, that's right. So, you know, thankfully we had same-sex marriage, but the problem, as Jamie alluded to, is what happens when you're not in Massachusetts or you leave Massachusetts. You know, you came to Massachusetts, you got married here, you now live, you know, in Nevada or Alabama. You can't get divorced because they didn't, you know, legalize, they didn't recognize marriage. You have to either come back to Massachusetts or do something else. So, you know, Obergefell took care of that problem, which essentially limited people from traveling from state to state and weren't afforded all the rights that you were able to have in Massachusetts. And even when you were able to be married in Massachusetts, you still couldn't take advantage of federal rights, such as filing joint tax returns and other benefits that are afforded to you by the federal government, such as federal pensions. So, you know, the courts do have to legislate because, you know, state by state, you know, we may have, you know, laws that protect those citizens, but then you leave one state and you go to another and you don't have those same protections. So that's why the Supreme Court is important in making sure that our protections exist even as we cross state lines and protect citizens, because it was a huge problem between 2004 and 2015 when you didn't have same-sex marriage throughout the entire country because people had severe limitations. It was problematic. There's about 1,000 or so rights that are afforded to married people that people weren't able to take advantage of until the Supreme Court stepped in, despite the fact that I think maybe about, I don't know, I think it was maybe 30 states had legalized marriage around that time, approximately, but you still had a long way to go before others did. And, you know, I think that many thought that hell would freeze over before all 50 did. So it was important. And that's why the states have to step in. If it weren't for the states, you wouldn't have, you know, Brown versus Board of Education, which dealt with, you know, discrimination laws. If you wouldn't have Obergefell, you know, the Supreme Court has for centuries helped people become, you know, protected under the equal protection laws. So.
Francine?
I remember during that time, it was really complicated as an employer to provide equal benefits for our employees across the U.S. So we had to do things like, you know, have employees sign affidavits, you know, that they were in a same-sex domestic relationship so that they could get equal benefits. And there were differences in tax implications, right? If someone was not in a marriage, there was marriage benefits, and people would be paying more for their medical benefits because they weren't married. So, you know, at the company I was beforehand, we would have to gross up. I mean, you didn't have to, but we thought it was right to gross up someone's pay to cover that differential. So, you know, the inconsistency in the states did cause a lot of workplace complications, but I think a lot of employers, you know, rose to the occasion and made sure that they were treating employees and their people equitably from a benefits perspective.
you might have to fill out taxes one way for the state and one way for the federal government.
Right.
You were married in one group, you weren't. So let me ask you, Michael, in light of these Supreme Court rulings, are things boring now at the law firm? Do you have all these, what are the family issues that are left? Because there were so many of these that I hearken back to and think of, and they seem to be gone. So they're right in your wheelhouse. You have a lot of free time now, or what are the issues that you spend your time on?
There's always, first of all, there's always something to fight about in family law. So never, no. So there's always, luckily you don't deal with a lot of the constitutional issues, which would prevent a lot of my clients from, moving out of Massachusetts and getting divorced somewhere else. But there's always something to fight about, which we can do a whole other Zoom topic about, money, custody. There's something, but luckily, people aren't fighting about, and people aren't trying to figure out how to divide their assets without the IRS protections. Divorced people can divide assets tax-free. If you're not married, you can't do that. So those issues we don't have to deal with anymore. But there were a lot of volatile economic issues that same-sex people had to deal with prior to the Obergefell decision.
So fewer differentiation between somebody who's practicing with mostly straight people and someone who's practicing with.
There's, luckily, I have to say, there's nuances still, but luckily from an economic perspective, thankfully for now, Obergefell has sort of leveled the playing field for same-sex couples and opposite-sex couples in terms of the economics.
So let me ask the three of you, if each of you, one of you was put in charge tomorrow of GLAAD, the other the Human Rights Campaign, and the third of Lambda Legal, and you went into your staff and looked at all the legal issues going on in the world today, do you have a sense how you would prioritize them? In other words, are we paying too much attention to the Supreme Court issues? Would you say, nope, we've got a lot of these issues in Alabama or Alaska or something to pay attention to, or in the workplace? Where would you tell your staff, this is the challenge today, that we've got to pay attention to this group? Francine?
Well, for me, I will add the organization ILGA.
Okay.
They look at this issue on an international basis, and the thing that, especially when I was at Microsoft working for a global company, I was always very worried about our employees who were limited by the lack of protections and laws in their international mobility, because that was a fantastic way for someone to grow their career. And again, I'm going to approach it from the workplace perspective, and I really think that there's a lot that we can be doing, well, probably not from a legislative perspective, but there's a lot to be done outside of the US too. Not to say that we've solved everything and that we are leaders, but I mean, there's a whole emerging markets where people just aren't safe to go. And that always concerned me for those employees.
Great. Other thoughts, Michael?
So it's a little bit of a detour, but I think I'm more concerned about healthcare and the Affordable Health Care Act, to be honest with you. I think that that's going to be a problem with the configuration of the court. And I think that
generally, for LGBTQ people or generally?
For generally, because I think that, and I hate to, veer off the LGBTQ topic, but, I think that I'm answering your question by saying that that's sort of my main concern right now.
I'll take that. I'll fire you from leading GLAAD or whatever and let you go run a healthcare advocacy organization. Jamie, anything you want to say?
I would just say the issue of the Pennsylvania case and cases like it that deal with this difficult issue of the balance between religious freedoms and non-discrimination laws. I don't think it's a difficult question. I think that no one should be giving the free blank check or carte blanche, if you will, whatever term you want to use, to discriminate against anyone, even based on your religion. But I think those questions are of concern and will continue to wind their way up the court system. But one thing I would add one thing too, just to this conversation. Mm-hmm. The topic is the Supreme Court, but I also want to say that we should be concerned about lower level courts too.
Mhm.
The Trump administration, President Trump has nominated and Senator McConnell has shepherded to appointment 218 federal judges, 218 Article 3 judges. 53 of them are on U.S. appeals courts, and they're going to be there for a while. His nominees strategically tilt towards younger, so they have so they can serve their life appointments go a lot longer. We should pay attention to that too. Is what I'm saying.
What kinds of issues would come up there that would be different from?
Well, I think that the issues wouldn't be different, but I think that we should monitor cases as they wind their way up. We shouldn't just wait to get them at the Supreme Court level. We should try to, the Supreme Court gets about 7,000 requests to hear cases a year, and they take about 80 cases. They take the cases that either result from a circuit split or a constitutional question. So if there's a circuit split, a difference between the circuits, those cases are more likely to go before the U.S. Supreme Court. If we pay attention to who's sitting on those appeals courts, maybe we're less inclined to have the circuit splits. There's more uniformity across circuits, such that the fewer cases. I think these cases will always make their way up there because they're of significance. They have constitutional questions that the court needs to address, the Supreme Court needs to address. But we shouldn't take our eye off of district court judges who have a role to play and U.S. appellate court judges who have an important role to play.
All right, I've got a few questions and not too much time. Francine, you had something you wanted to add?
Yeah, I just wanted to add it. I'd be remiss to not bring up, since you brought up the Human Rights Campaign, in their opinion related to this case, they really wanted focus on the Equality Act, right, which is explicit non-discrimination across key areas of life. So it's not just, it's broader and not as narrow. So it looks at employment, housing, credit, education, public spaces and services, federally funded programs, and jury service. So that's something, for those who are interested, you could look at the Human Rights Campaign site, and there's a lot of great detail on that.
Phil Dardeno asks us, in terms of how the ruling affects employment protections, are there any differences you anticipate in the impact of government employees versus private employees, private company employees?
Well, that's a good question. I mean, I think the election couldn't come soon enough. There was an executive order, this is somewhat related, which said that federal contractors and the federal government could no longer provide diversity inclusion training, which spoke about bias in a way that made someone feel bad or that included unconscious bias. Mm-hmm. So I'm just sharing that executive order because that is a signal in my mind of the way that at least currently the federal government is leaning. So it's something that us human resources executives are grappling with right now is, interpreting what the executive order is and the impact on the workplace, because certainly bias comes to play in this area.
It's a great example because one of the questions I was thinking, and we got close to it when we were talking to, when one of the points Michael was making about whether, while the Supreme Court is important, to what degree we really need to focus on local laws, executive orders, agency rulings. Jamie touched on lower court rulings that really still lay obstacles and prevent sources of difficulties in people's lives. Some of them minor and some of them not so much. Can I ask you a question? Is it fair to say that in the LGBTQ, that the lesbian and gay people are in a better situation than transgender people right now? We have them lumped together as one, but should we really separate them out and look at them differently? Is there a much more different legal landscape for transgender people?
I think there are different issues, that transgender individuals deal with than non-transgender individuals in the workplace, in the workforce, and in life. I think that, and part of it is cultural. There's been more awareness for LGBT rights, and it's been only recently that there's been more awareness for transgender rights. So hopefully, as people are more informed about transgender rights, that will hopefully change. And as the courts are more informed about transgender rights, hopefully that will change. But so there are nuances, such as what people call bathroom bills and things of that nature. So I think that there's a lot more work to do, in my opinion, in the transgender community, especially in their ability to serve in the military, the healthcare rights, so their social rights. So I think there's a lot more work to do in the transgender community, is my opinion.
Got a few questions floating in, and I'll just try and do some that may be, well, once you can tell me, this will be a short one for everyone. What's the likelihood Trump's nominee, Amy Coney Barrett, will be appointed? So I think this is a student question. So you can give me a quick.
I think, unfortunately, yes.
Jamie?
I think yes. The only thing that could stop disappointment is I don't COVID, and I don't wish anyone ill. Absolutely don't. But I think the only uncertainty right now is the Senate's ability to meet and actually vote, and to have the senators there. The Republicans can only lose 4. They can lose 3. If the 3, but then they have the vice president to break a tie, and so. I think, but it looks like there's gonna be very little stopping Mitch McConnell from pushing this nomination through.
Francine?
I sadly think that they're right, and I pray at night that they will be wrong. I'm hoping for no, but I think realistically, probably yes.
Somebody asked anonymously, will that executive order that Francine mentions, will companies lose budgets for those unconscious bias trainings? Will people who receive federal funding, perhaps, maybe Holy Cross will? We can't do diversity training anymore?
That's a good question. The executive order came out recently, so people are still trying to understand and unpack the implications. I can say from what I've read from corporations and from my firm's perspective, we certainly are not looking to decrease investments in learning and development on this topic. It certainly is not the right time to do this at all. As a matter of fact, I think a lot of places are increasing their efforts. In terms of if it's a federal funded, I'm not sure what that means. Where I am right now, we're not federal contractors, but we are just staying close to the law to understand the implications for future. And then from a Holy Cross perspective, that's something that we'll have to determine and find out for sure.
I'll let everyone do a little wrap up because we're almost at the end. Rich Iandoli, who's an attorney, asks maybe a question that's hard for all of you to answer, but why you believe that so many Supreme Court conservative and anti-gay judges are Roman Catholic. There's a whole mystery, lots of articles about how many Catholics on the court, and in fact, very few evangelicals. There used to be 1 seat on the Supreme Court, as Rich would know, he's an attorney.
But don't you think that's political? Don't you think that's by design, the politics that the presidents who appointed them, were aware of their ideologies, and
there's no Catholic vote in the United States, so it's very difficult to appeal to that. So as a political strategy, it's hard to see that.
But wouldn't the president think that those particular justices are probably more more anti-abortion and more anti-gay? I mean, that's probably how that came about now.
I mean, I think some of it certainly, there are very few, Unitarians. If I went to a Unitarian setting or a UCC setting, I'm not going to find many of those. So I get that. Then there is more of a spread among American Catholics. But the data around American Catholic opinions about abortion, if I only had a survey that told me what American Catholics think, it would be a pretty good proxy for what Americans think generally on abortion. So they are choosing from one end of the spectrum. It's a fairly deliberate choice. That's there, there's no doubt. But I would tend to agree, given that I'm answering a little bit, but I deal a lot more with the religion things maybe than some of you, but that in fact, these are people whose ideology determines their religious faith to some degree. Almost every, Jamie talks about being a progressive Catholic. people do choose within the big sphere of things that are part of the Catholic perspective. So one of our chat people is saying the Catholic legal movement is closely tied to the Federalist Society, which is true. But I would say the big answer, the question that I keep coming back to is, why not more evangelicals then? Huge number of Southern Baptist people that they could have chosen that from, and I just don't have a good answer for that. So anything I missed out on that any of you wants to highlight before we end?
Vote.
I already voted.
Vote. And volunteer with your volunteer, making phone calls to we can't knock on doors, but to help protect the vote. And I think that's what we have in our control right now.
And tell other people to vote.
Yeah.
Francine, any?
Yeah, I mean, I think that's an important message to leave people with. I think, you know, just to tie a bow on the transgender piece, there are standards, WPATH standards. So for those who are interested in learning more about that from a benefits perspective, certainly that's another resource to turn to. That was the only thing in my notes that we didn't get to, but thank you.
Well, I appreciate with everyone that we covered some of those legal issues, but also extended ways in the workplace and in terms of the cultural, social issues that are also genuinely important ways to bring about change for LGBTQ people. So thank you everyone who logged in. Thank you to Phil for setting us up with this. And thank you very much, Tom Cadigan and the Holy Cross Alumni Association, broadly speaking.
Thank you.
Thank you.
Thank you, everybody.
Thank you.